With all the talk of the Renters' Rights Bill, exactly what rights will tenants be getting in 2025, maybe as early as the summer? Well, we've all heard a lot about the abolition of Section 21 no-fault evictions in 2025. In fact, I've done a whole video on it, and you can find it. But the Renters' Rights Bill will give tenants a lot more rights than just that. In this video, I explain what's changing from the tenant's perspective, starting at the beginning when someone is looking for a property and mapping out the entire customer journey, as they call it in business, until they decide to move on or the landlord decides that they want to terminate the agreement. And so I go through each stage and I explain exactly what new rights tenants are getting. So who am I? And why am I talking about tenants' rights? Well, I'm Suzanne Smith, a lawyer turned landlord, and I run the Independent Landlord website and YouTube channel to provide straightforward, balanced, and practical information without all the politics. And I think it's important for we landlords to understand the perspective of our tenants, because tenants are our customers. And like any business, we need to have the customer experience at the heart of what we do and the decisions we make. And also, on a personal note, my daughters are both renters, and they've had a rocky time with some pretty appalling landlords, although some of them have been okay. So I dedicate this video to them. It's a YouTube video of how I've explained their new rights to them, or the new rights that they'll be getting in 2025. Let's get started. Let's have an introduction to the Renters' Rights Bill from Angela Rayner.
And I want to be clear from the outset that this government recognises the important role of landlords, most of whom provide good quality homes to their tenants. But this is a sector in serious need of reform. Millions of people live in fear of Section 21 no-fault evictions that could uproot them from their homes and their communities, and are forced to live in homes that are riddled with damp and mould, too scared to complain in case they end up evicted and homeless.
Well, first things first, the Renters' Rights Bill gives tenants a lot of rights to help rebalance the relationship. But it's not one-way traffic, because tenants have responsibilities too under their tenancy agreements. That's part of signing a tenancy agreement. Both the landlord and the tenants have rights and responsibilities, and the Renters' Rights Bill introduces a few more responsibilities for tenants, but a lot more responsibilities for landlords. I worked as a lawyer for 25 years, and I know from experience that contracts, once they're signed, normally just stay in the drawer or the electronic filing folder, because when things are going well, you don't look at them. And because what's important is the positive relationship where both sides are happy, both sides hold up their side of the bargain, treat each other with respect and communicate well and do what they're supposed to do. Right, we're now starting the customer journey, the start of a relationship between a landlord and tenant. And that starts at the viewing stage. And prospective tenants have a lot of new rights before they sign on the dotted line and become tenants. Well, the first one that you may have heard of is no rental bidding is allowed. And also, when you see a property advertised once the bill becomes an act and it comes into force, there'll be no changing of the goalposts regarding rent. So what's going to happen is landlords, when they list a property, they must set a proposed rent and not accept offers above it. This means that prospective tenants will know that they won't have to offer more than the amount of rent that's mentioned in the listing. In fact, the landlord won't be able to accept an offer from a tenant who wants to pay more than is in the listing. And the intention behind this is that it will mean that rents won't ratchet up when you have a hotspot and lots of tenants are chasing the same property, and the person who wins it is the person who pays the most. This doesn't happen in all parts of the country, and it certainly doesn't happen where I am in Kent, but the government is trying to put an end to the practice of rental bidding where it does happen in England. The second thing is that when a tenant is considering renting a property, is that they'll have access to information about the landlord and the property on the new Landlord Database. Now, we don't know exactly what's going to be in the database because the government hasn't published it yet, but it's likely to include whether the safety certificates like the gas safety certificate and the EICR, which is the electrical installation condition report, whether they're satisfactory and uploaded. It might have details of any licensing. And so it means that the tenant will be able to check out the landlord before they sign on the dotted line. And this has real teeth. If the landlord doesn't register for persistent breaches of the rules, they could be fined by up to £40,000, and tenants can apply for a rent repayment order. The third thing at the viewing stage is that landlords and letting agents won't be able to discriminate against applicants if they're a family or on benefits, or if they have a child coming to visit the property. So this means no more DSS adverts. Landlords and letting agents won't be able to stop someone from viewing the property or finding out about the property just because a child would live there or visit them there. And they won't be able to stop somebody from viewing a property if they are on benefits. However, there are a couple of exceptions to this. And so on the family discrimination, there is an exception for proportionate means of achieving a legitimate aim. And so that might mean a landlord of an HMO might have an age rule saying that people have to be adults, and they could turn down a child wanting to rent a single room in an adult HMO. Or there might be concerns about overcrowding. There might be, say, like a one-bedroom flat in a family of 5. It would be legitimate for a landlord to turn down an application for a family to live there because that would lead to overcrowding. And with the benefit status, the landlord or the letting agent will be able to take into account the income of a prospective tenant, the amount of money that they're receiving into their bank, which may include benefits. And they can take that into account when undertaking affordability check. Let's take a concrete example of where the monthly rent is £1,500. Now, a good rule of thumb is that a tenant or the household should be receiving income into their bank accounts that's equal to 2.5 times the monthly rent. So here that would be £3,750 a month. And the landlord will be able to take into account if the amount of money that the applicants are receiving is less than that, say if it's 2,500 or 3,000, because the tenant wouldn't be able to afford it. But what the landlord won't be able to do is to say, oh, well, some of that is universal credit, and therefore I'm discounting that. And there's another really interesting provision in the Renters' Rights Bill, and that's if there are terms in insurance contracts, in new insurance contracts, all landlords take out landlord insurance, or good landlords do, and for existing and future mortgages, if there are terms in those contracts that discriminate against children or the benefit status of tenants, then they're going to be null and void. And unfortunately, at the moment, landlord insurance commonly says that that landlords should let to professional tenants, whatever that means, and not tenants on benefits. And when it comes into effect, any new landlord insurance policies that have that term will be null and void. And so that means that landlords wouldn't have to worry about being in breach of their insurance obligations just because they let to somebody who's on benefits. And sometimes a tenant might move in and not be on benefits, and then they suddenly get benefits. So what's a landlord to do if they have one of these insurance obligations? Are they supposed to evict the tenant just because they're receiving some benefits? I mean, that would be an awful thing to do. So I'm, for one, and pleased that this is coming in. And this comes with real teeth, because if the landlord does discriminate and the local authority shows that it's on a balance of probability, so it's more likely than not that the letting agent or the landlord has breached these anti-discrimination rules, then they can be fined up to £7,000, which is a lot of money. So let's move on to the next one, pets. There's been a lot of talk about how tenants are going to have the right to have reasonable pets, but it doesn't, at least in the version of the bill now, it doesn't include people who haven't yet moved into the property. So if you're looking for a property and you have a cat, the landlord can turn you down because you have a cat. But if you move into the property, you can then ask if you have a cat. So it's just a little bit complicated there at the viewing stage. So another new obligation is that properties must meet the decent home standard, and we still don't know what that means. And the Secretary of State, so at the moment that's Angela Rayner, she'll have the power to say what it means, and it will cover the state of the repair of the premises and the things that have to be provided for tenants and the means to keep it at a suitable temperature. So all of this will need to be in place before the tenant moves into the property. And we don't know exactly how it's going to work. There may be some kind of self-certification from the landlord. And that will be another right for a tenant, that is to live in a property that meets the decent home standard, whatever the decent home standard is. And if it doesn't meet the decent home standard, then the local council will have a lot of enforcement mechanisms. And so this includes issuing an improvement notice requiring the landlord to put right the problems within a specified timescale. So if landlords don't comply with the enforcement action and an offence is committed, then the tenant can apply to the first tier tribunal for a rent repayment order for up to 2 years' rent. So that is a big new right. And this is on top of the property needing a valid gas safety certificate, EICR, that's the electrical installation condition report, and to be free from serious hazards. And the guidance from the government says that this new right will incentivise all landlords to proactively manage and maintain the safety and decency of their properties. So one more thing is that landlords will have to give tenants or prospective tenants a statement of the terms of the tenancy before they sign it. We don't know exactly what they're going to be, but I do think that these days most landlords do enter into tenancy agreements with their tenants, and the tenants would obviously see the tenancy agreement before they sign. So I'm not expecting that to be a big change. Right, so let's move on to section 2. And that's what happens when tenants sign up to a new tenancy agreement. And there are a lot of changes. So the first big important one is the type of tenancy is changing. It will now be an assured tenancy and not an assured short-hold tenancy. Now, I know the words sound pretty similar, and the difference is the absence of the word short-hold. But what does this actually mean? Well, first of all, there will be no fixed-term tenancies, not even for students, at least that's the way it's drafted at the moment. And there will be no minimum period, no renewals. And so it means that tenants will be able to leave whenever they like, provided they serve a notice in writing to quit at any time. And the notice to quit has to be at least 2 months to expire at the end of a rental period. And the notice in writing can be in an email or a text message. It doesn't have to be on hard copy paper. When I say that the 2 months notice to quit needs to expire at the end of a rental period, let me explain what that means. So if you have a rental period that is monthly, that goes from the 2nd of the month, then the rental period is said to end on the 1st of the month. And it means that if a notice is given by a tenant on, say, the 15th of July, the contract, but the tenancy agreement won't come to an end on 15th of September, 2 months later, but on the 1st of October, because that's when that rental period will expire. So it's a little bit complicated, and it means that it may be a little bit more than 2 months' notice. And landlords cannot make tenants give more notice, and any term in a contract that says this is null and void. And landlords won't be able to terminate a tenancy by giving 2 months' notice as they can now by using Section 21, because Section 21 is going to be abolished. I'll go into that in more detail, but instead landlords will only be able to terminate if they fall within certain grounds, which I'll talk about in a little while. So the next thing is the rental period has to be no more than monthly. And the overwhelming majority of tenancies at the moment are monthly, but sometimes tenants pay, if they're students, they might pay by the term or they might pay in bigger chunks, but that is now not going to be possible. So this brings us on to section 3, which is the rights that tenants have during a tenancy. So the first one is changes to rent increases. This is changing a lot for landlords. And at the moment, landlords can use a rent review clause that's in the contract. They can do it informally or do it by an addendum or by a renewal. But renewals are going to not be there anymore because there's going to be no more fixed term. So the only way that landlords are going to be able to increase rent once the Act comes into force will be by serving what's called a Section 13 notice, giving at least 2 months' notice of a rent increase. And they'll only be able to do that once a year. And all the other methods won't work. And tenants are going to have increased rights to appeal against rent increases. Let's hear what Matthew Pennycook has to say about this.
All rent increases for private landlords will take place via the existing Section 13 process, so the tenant can challenge them if necessary. This will protect landlords' rights to achieve market rent while preventing abuse. We'll also give tenants longer to prepare for rent increases and only allow one rent increase per year. Tenants have feared challenging a rent increase at the first-tier tribunal. We will end this by ensuring, in contrast to the previous government's legislation, that a tenant will not pay more than the landlord asked for in circumstances where a tribunal might determine otherwise. And we're going further. We will end the practice of backdating rent increases that stop tenants from being thrust into debt if they take a case to tribunal.
What happens if tenants aren't happy with a rent increase? Well, they'll be able to appeal it to the first-tier tribunal, who will decrease the rent if the proposed rent is above what's market for a similar property in that area. And the rent increase will be delayed until the first rent payment after the first-tier tribunal makes the decision. So this is a big new right for tenants, because at the moment, if a landlord serves a Section 13 notice, because they can do that already, they have a risk when they go to the first-tier tribunal, because the tribunal can increase the rent above what the landlord's proposing if they think that the market rent is higher. And so there aren't actually that many challenges of rents at the moment in the first-tier tribunal, and the government is trying to change that. The next change is the right to request a pet. And I mentioned this briefly before. Existing tenants have an implied right to keep a pet, and they have to follow a particular process. They must ask in writing, and they must describe the pet for which they're asking consent. And the landlord must reply and give an answer within 28 days. And if the tenant isn't happy with the answer, then they will need to either go to the court or to the new landlord ombudsman. The landlord will be able to turn down a request to have a pet if they've got a good reason, and that might be the pet is unsuitable for the property, there might be too many pets, or there might be allergies or an HMO when it might be inappropriate, and the government's going to publish guidance on this. The next one is AWAB's law, and you might have heard about the horrible case of toddler Awab Ishak, who died as a result of inhaling mold spores in his parents' social housing flat in 2020. And what AWAB's law does, which is already there for social housing, is it sets clear expectations about the timeframes within which landlords will need to see to repairs. Now, in the social housing sector, the detail still hasn't been published, and we don't know exactly the timeframes for social housing, and we don't know what it's going to be for the private rented sector. The government has indicated that they do understand that most private landlords don't have their own in-house repair team, maintenance team, and so they'll take that into account. But it means that landlords will have a positive obligation to respond and try and get to the bottom of serious hazards. If landlords don't comply with this, then tenants will be able to challenge them through the court system for breach of contract. And they'll also be able to make a complaint to the private sector landlord ombudsman. So what's the private sector landlord ombudsman? Well, there's already an ombudsman or redress schemes in place for letting agents, and they're the property called property redress and the property ombudsman. Now, there's going to be something new set up for tenants that they will be able to take complaints about their landlords to this independent third party, and it's likely to be the same ombudsman as for social housing, although that still hasn't been confirmed. And it's going to be free for tenants, and the ombudsman will make a decision and the landlord will have to comply with it. So if a tenant uses letting agents, they will be able to have the choice of going to the letting agent redress scheme or the landlord redress scheme, and it will depend on what type of complaint there is. For instance, if there's a complaint about a landlord not accepting pets, then the landlord ombudsman would be the right one for that. Whereas if it's something to do with the actual letting agent service, then the letting agent's redress scheme would be the right one for that. So let's move to tenants' rights at the end of a tenancy. Now, as I mentioned, landlords will no longer be able to use the Section 21 no-fault evictions, which really means that landlords can evict a tenant so long as they're not in a fixed term at the moment without giving a reason. And that's going to be abolished. And after that, landlords will only be able to bring a tenancy to an end themselves if they have a good reason under what's called Section 8 of the Housing Act. And the main ones are these. The landlord is selling up, the landlord or their family are moving in, rent arrears, antisocial behaviour, or breach of tenancy agreement. So if the tenants aren't looking after the property properly or not giving access for repairs or having a cannabis farm subletting, that sort of thing. And landlords won't be able to give a notice to quit, and they can be fined up to £40,000 and be found guilty of unlawful eviction if they do this. And unlawful eviction is already on the list of offences that will entitle tenants to receive a rent repayment order, and the rent repayment orders are increasing by double up to 2 years' rent. So while we're talking about rent repayment orders, let me just explain about them a little bit. So rent repayment orders are already there. Tenants can already go to a tribunal if their landlord has been guilty of certain offences like operating an HMO without a licence or unlawful eviction, and they can claim up to 1 year's rent if it's proven that the landlord has committed these offences. So what's going to be happening when the Renters' Rights Act comes into force is that instead of 7 existing offences, there'll now be new offences relating to the Renters' Rights Act. And so this will give landlords a lot more concerns about breaching the Renters' Rights Act, because there are lots of new offences and a lot of money is at stake, up to 2 years' rent, which is a lot. Now let's talk about when will tenants get all of these rights. And here's a clip of Matthew Pennycook explaining what's going to happen.
To avoid confusion and to ensure that renters on existing tenancies do not have to wait even longer for the threat of arbitrary evictions to be lifted, we intend to apply the new system to all tenancies in a single stage.
The new tenancy system will come into effect on a Big Bang date, and altogether both for existing tenancies and new tenancies. Matthew Pennycook has said it might happen by the summer, but I personally think it's more likely to be in the second half of the year, because there's an awful lot of things to put into place before it can come into effect. So I think it will be the autumn of 2025 at the earliest. If you're watching this in the autumn of 2025 and it's already in force, well, I got it wrong. So we don't know exactly when it's going to be, but that whole raft of things will come into effect on the same day. And The things that we're not sure about when's going to come into effect are the things like the Landlord Database, or about IT projects. They always take a very long time. And also the Ombudsman, the Decent Home Standard, AWAB's law, they'll all be going out to consultation, and we'll find out about them in due course. And I'll be sure to do a video about it when we do have more detail. So this brings me to the end of this session on the new rights that tenants will be getting under the Renters' Rights Bill, the Renters' Rights Act as it will be. And if you've got this far, it would be really great if you could subscribe to my channel so you don't miss out on future videos, or at least give it a thumbs up. I'm doing all these videos to try and help educate everybody in the private rented sector and trying to make it really balanced and fair-handed between landlords and tenants and without all the politics. So you can check out my video on what will happen when Section 21 is abolished. And in the meantime, I'll see you soon.